When it comes to the accidents happening at sea, the laws ruling these situations seems very complex and confusing. This is when the law of the sea and maritime law comes into the picture. Law of the sea and maritime law, as the names suggest, seems very identical to each other. An ordinary person might perceive that both laws deals with the shipping industry. However, this is somewhere not completely accurate, as law of the sea and maritime law covers very different matters from each other. So let's see how both law of the sea and maritime laws are different. Starting from the maritime law, as compared to the law of the sea, maritime law has much narrower jurisdiction. It usually covers private entities. Private entities would include ship owners, their employees, and any clients that ships might be on board. In most developed countries, maritime laws follow a separate code and is an independent jurisdiction from national laws. For example, in US, the Merchant Marine Act of 1928 is followed. The Death on High Seas Act is followed. Talking about the law of the seas, it is very vast as compared to the maritime law, as it is a body of public international law. It covers coastal states and rights and duties among the states. It can be used in the conservation of the ocean environment and its natural resources. It is associated with international treaty, that is, Convention on the Law of the Sea. Convention on the Law of the Sea was negotiated and signed in 1982 by 117 states and entered into force in 1994. It is best understood as a framework providing a basic foundation for the international law of the oceans, intended to be extended and elaborated upon through more specific international agreements and the evolving customs of states. It covers matters like jurisdiction over coastal waters, ownership of natural resources, navigational rights. So thus we can conclude that maritime law is only applicable to the ships or the countries whose laws it belongs to, but law of the sea will apply to all the countries who ratified the treaty. Mainly private sectors are dealt with under maritime law, whereas government authorities take care of the application of law of the sea. If a country has ratified law of the sea, they codify those terms in the form of maritime laws in the domestic countries. Maritime law is domestic, whereas the law of the sea is international. Law of the seas may override domestic maritime laws, but maritime laws cannot override the law of the seas.